Hello, everybody. Thank you for having me. I'm so happy to be part of this conference, and I'm very sad, as almost everybody else, not to be with you. And I hope this whole horrific thing ends soon and we can meet up all together very soon. So 15 minutes is actually not a lot for such a presentation. However, many similarities between the court settlements and the authentic instruments have been pointed out already. So I think I can quickly go over some of the things I wanted to say and actually speed up the whole thing. So there's two things I would like to do today. I would like to give you a brief overview over the enforcement of court settlements in other member states. And I would like to delve into a little more depth into some specific problems, as you will see very soon. So what is awaiting you in the next 15 minutes? I will show you the relevant provisions and also the changes from Brussels 1 to Brussels 1A. Then I would like to discuss with you the definition of a court settlement within the Brussels 1A regulation, and also discuss the scope of the regulation in regard with court settlements, because there are actually some interesting problems that can arise on that topic. Then I would like to go through the requirements for the enforcement of court settlements, but this is something we've heard before, so can actually speed up that part, and also talk real quick about the recognition of court settlements. So what are the relevant provisions and changes from Brussels 1 to Brussels 1A? So now we have in Article 2 a definition of court settlement. For the purposes of this regulation, court settlement means a settlement which has been approved by a court of a member state or concluded before a court of a member state in the course of the proceedings. And Article 59 is the most relevant provision, together with Article 58, but we've heard about that before. Article 59 says a court settlement which is enforceable in the member state of origin shall be enforced in the other member states under the same conditions as authentic instruments. So what has changed compared to Brussels 1? There's only a few minor changes. First of all, there's a larger scope of the definition. While the old regulation said as court settlement is a settlement which has been approved by a court in the course of the proceedings, now the definition says it's a settlement which has been approved by a court of a member state or concluded before a court of a member state in the course of the proceedings. So any dispute on whether I'm going through that more in detail later, but any dispute on whether settlements that have been made out of court and just documented at court now should be over. Then there's a small change in wordings. The old regulation said that the court settlement shall be enforceable. Now it says it shall be enforced. Personally, I think this is just a linguistic adaptation, possibly to the abolition of exequatur. Interestingly enough, the German version, which says werden vollstreckt, has not changed at all. And the third change is there is a reference to Annex 2 now instead of Annex 5, and the annex has been expanded largely. So let's talk about what is a court settlement. So as I said before, it's a settlement which has been approved by a court of a member state or concluded before a court of a member state in the course of the proceedings. And this is also kind of weird, honestly, because it was the definition was enlarged. And if you look at the German version, it's kind of vice versa. While the old English version said which has been approved, and now it says approved or concluded, the German version said concluded, and now it says approved or concluded. Really, I think now it's clear that both types of court settlements fall under this definition, and that's about it. Settlements. There's an important judgment from the ECJ, the Solo Kleinmotoren judgment, where the ECJ defines that settlements in court are essentially contractual in that their terms depend first and foremost on the party's intention, and that will be of interest a little later. Just to give you a short idea of what a court settlement is from an Austrian point of view, in Austria, it is an agreement recorded in court on the content of rights or legal relationships which are suitable for settlements. We have three types of settlements. We have the classic court settlements during the proceeding. We also have a pretoric settlement. I'm actually not quite sure about that word. I looked it up in German. It's pretorischer Vergleich, but I'm not exactly sure if that's the right word in English. Basically, what it means is that before the start of a proceeding, two parties can actually go to court and try to get mediated by a judge and conclude a settlement. And then now we have the mediation settlement, which is very, very similar to the pretoric settlement. Actually, the court settlement is something that most or probably all member states know. However, the concept of court settlements is quite different in various member states, and also it's heavily disputed in some of the member states, for example, in Austria or in Germany. One interesting problem arises here if we want to try to distinguish between a court settlement and a judgment, because there are some legal acts in some member states that are sort of in between those two things, right? They're on the borderline, such as the English consent judgment, which I'm afraid is not going to be much of a problem in the future, or the French jugement d'expédition. And so the question, since there is a completely different regime of enforcement and also recognition between these two instruments, it's very interesting to know if it's actually a court settlement or a judgment. So there are some suggestions in legal literature for distinguishing features between those two things. Some say we just have to make a formal distinction. So if the act in question takes the form of a judgment or another decision, it is a judgment. Otherwise, it could be a court settlement. Other authors say that it's more about the functional role of the court. So if the court only has a function of documentation, it's a court settlement. If it's a decision on the substance, then it's a judgment. And there's also some authors that say it's we should look at the effects of the act in question. So if the act has judgment-like effects, such as the res judicata effect, then it is a judgment. Otherwise, it could be a court settlement. Honestly, I think if you think about these propositions, you will always find some cases that do not really match these propositions, or that where it kind of you come to weird conclusions. My guess is if the act in question is predominantly contractual, and that also actually fits the definition of the ECJ, then it's a court settlement. If it's predominantly a judgment from a body with sovereign authority, then it is a judgment. And there you can take into account actual formal aspects, but also the functional role of the court. I think the effects of the act in question are really not a good parameter to look at, because, for example, some court settlements, I really want to talk to Jerzy about this, because this is such an interesting question, since he said actually Slovenian court settlement is a judgment under Brussels 1A, and I would like to know why this is the case. But there is definitely member states, and from my point of view, Austrian court settlements also have a res judicata effect. Still, I would say it's a court settlement, also in the light of Brussels 1A. So another from my point of view, interesting problem is arises from the scope of Brussels 1A, because and I'm not going to discuss the scope of the regulation. You can be reassured. However, there's a special problem regarding court settlements, because they can contain claims that would fall under two or more separate regulations. Because in one court settlement that can of course be settled 2, 3, 4, 5 or more different claims. And this whole thing is less problematic if the different claims can still be identified as separate claims. Then each individual claim is subjected to the corresponding enforcement regime of the respective regulation. The real problem arises if those, I call this blended beyond recognition, right? So let's say there is a car accident, and one party wants the damage, has a damage claim, and by incident, the causing person of the car accident is also the father of the other person, and there are some maintenance claims, right? And then in a court settlement, they agree on just the payment of 10,000 euros. So what do you do with these court settlements? There are also some suggestions in literature Some say, well, we should look at the main emphasis of the court settlement. Others say we should apply the more special regulation. So, for example, in this case, probably the maintenance regulation would be more special than the Brussels 1A regulation. I really don't find those things very convincing. You can definitely find cases where there is no main emphasis or no clear main emphasis. And you can also find cases where there's no more special regulation. I mean, if you have Brussels 1A, probably the other regulation will be more special. But if you have some family law claims and you have, for example, Brussels 2A and the maintenance regulation, then it gets much more difficult already. So I actually really don't have a solution for that. Maybe you can give me some inspiration. One guess could be that if those claims are really, as I say, blended beyond recognition, then they are just a civil claim and no special claim that can be contributed to any regulation anymore. And that would mean that they fall under Brussels 1A. But I'm really not done with my thought process on that. Okay. So we already heard a lot about the requirements for enforcement on authentic instruments, and this works mostly the same for court settlements. So the most important requirement, I guess, is the enforceability in the member state of origin, and this corresponds to Article 39 for judgments and should also be interpreted accordingly in most aspects. This is, of course, a question of abstract enforceability. What does that mean? So if the enforceability of the court settlement is possible, for example, only after the provision of a security or an offer of a service in return or something, that means that this is also a prerequisite for the enforceability in other member states. The lack of concrete enforceability, for example, if the debtor has no assets in the member state of origin, this is, of course, no problem for enforcement in other member states. Then we need the certificate according to Article 60 Brussels 1A. We've already heard a lot about this as well. I'm not going to go through that in detail anymore. Basically, the certificate contains information on the issuing court and the parties, and detailed information on possible monetary claims. Non-monetary claims are not. There's not a lot of detail on that. There's only a header, short description of the enforceable obligation. The fact that there are many details on monetary claims is actually helpful because in many times it will spare a translation of the court settlement, which otherwise could be necessary according to Article 42 and 43, I think. And also the indication whether the court settlement is enforceable in the member state of origin. Then there is no more exequatur, as we all know, so no more need for a declaration of enforceability. And there's only one ground, as we heard before as well, for authentic instruments for a refusal of the enforcement, which is the public policy infringement, the ordre public. However, and that's also kind of interesting, it's possible to make the court settlement a European enforcement order. And in this case, not even the public policy infringement can be raised as a ground for refusal. Lastly, I would like to talk to you about the recognition of court settlements. The prevailing doctrine, and I do agree on that point, says there's no recognition of court settlements within Brussels 1A, especially because there's no reference to the provisions on recognition in Article 58 to 60 Brussels 1A. However, as Bettina Nuna-Krautkasse said before, there are some voices that say that the effect of enforceability can be subject to recognition, at least for judgments. If this is the case for judgments, you could at least argue that court settlements are, or at least the effect of enforceability is recognizable. This is more of an academic problem, if you ask me. There's little practical consequences from that. We really know how to enforce them, and it actually doesn't matter a lot, I think, if you say this is a recognition or not. It is interesting, though, that there is recognition within other European regulations, for example, within the regimes of Brussels 2A in Article 46 and the regulation on maintenance obligations in Article 48. And there, of course, we again have the problem if we have two or more different claims that are subject to two or more different regulations. Suddenly we have, and for example, the court settlement has a res judicata effect in the member state of origin, that actually part of the court settlement would be recognized and also the res judicata effect, whereas other parts not. but I guess this is just a phenomenon we have to live with. So yeah, that's basically my presentation. Thank you for your attention, and if there's any questions, I would very much like to discuss with you. Thank you.